It's stunning that 70% of your colleagues, like, we walk in with our, we just out the door, right? How did that manifest itself, what you just described, this lack of interest in enforcing the civil rights laws of the country, the lack of interest in standing in between the pillars of the rule of law that touches on every aspect of our lives? How did they do that? What did they say? They just basically, like, you would bring a case or a matter and they go, no, we're not doing that. Or they just tell you directly, guess what? Don't waste your time. We're going in a different direction.
Yeah, I think it was pretty direct. I think the realization sort of slowly dawned on people that there was no interest from this administration in enforcing civil rights laws. And not only that, they were going to weaponize those same laws against the very people they were designed to protect.
How? What's an example? 'Cause like in Chicago, for example, there's a civil rights, an investigation has been opened from the Civil Rights Division into the mayor because apparently he's hired too many Black people in Chicago.
Right. Well, that's a perfect example. So Title VI, and this is a law that only the Justice Department has the ability to enforce.
What's happening, friends? Welcome to Dr. John Podcast right now. Nearly 2,900 attorneys have left the Justice Department in just 10 months under the current administration, a 70% loss in the Civil Rights Division, and nearly 2/3 of the federal programs branch. The exodus of experienced litigators, including at least 10 supervisors, represents an institutional crisis that is unfolding in plain sight. The reasons these lawyers are giving when they're willing to speak with journalists are deeply troubling. They're not complaining about bureaucratic red tape or seeking better job opportunities elsewhere.
So there's a wonderful civil rights bar, but they can't enforce some of these laws. Only the department can do it. And so with Title VI was there to protect people against discriminatory actions. And so instead of using it to protect people against genuine discrimination, they're using it to act on reverse discrimination and really on cases with very thin evidence. And they're using it to engage in pressure campaigns like the one we saw against UVA on a very, very thin read. You see a department that used to act with enormous integrity and detail and ability to really bring that case and have people listen. This department is not checking those boxes or going through those details before they do it. They're willing to just make the accusation. And unfortunately, it's working. They're able to use those civil rights laws against people that they were meant to protect.
Can you tell us a little bit about the work you did in the wake of George Floyd's murder? Because I think it helps illustrate some of what it was that the Civil Rights Division was working on.
Yes. So I was on the team that investigated the Minneapolis Police Department after George Floyd was murdered. We opened that investigation to look into what we call a pattern or practice of misconduct by police departments.
They're talking about ethics. They're describing being asked to make arguments they believed were legally indefensible. They're expressing fear about being ordered to misrepresent facts or legal precedent in court filings, actions that would violate their professional obligations and potentially put their law licenses at risk. This is not a story about political disagreements or personality conflicts. This is a story about the systematic hollowing out of the institution that is supposed to ensure the federal government operates within the bounds of the law. The significance of this exodus cannot be overstated.
So not what one officer did, but what were the problems across the department, those deep institutional problems that made what happened to George Floyd possible. So that was the investigation that I worked on most intensely while I was there. And we put just an enormous amount of effort into going through documents really meticulously and really understanding the department's policies. We issued the findings of our investigation to explain systemic violations that we saw in use of force, in First Amendment rights. But the next thing that we do, we don't hold our punches in the Civil Rights Division when it's time for investigation, but then we would turn around and work alongside the jurisdiction to improve it and gain their trust and really work collaboratively with them. We've been able to do that successfully in so many places across the country. And we were really excited to do that in Minneapolis, and we just won't have the chance.
And then what happened?
Well, we had been hoping to continue our work with the city. The city wanted us to be there, helping them with their reforms. But then a few days before the anniversary of George Floyd's murder, the new administration pulled all of the investigative findings that we'd put out.
When you lose that many experienced attorneys in that short a period, you're not just losing warm bodies, you're losing institutional knowledge that took decades to accumulate. You're losing professional judgment that was honed through thousands of cases. You're losing the credibility that comes from having lawyers who have built reputations for honest dealing with federal judges over years and decades of practice. And what's filling that void is something very different. Lawyers whose primary qualification is their ideological alignment with the administration rather than their professional track record.
Said they would no longer stand by them and they would no longer act on those cases to remedy those violations. So that includes places like Memphis, where we found another really, really troubling pattern, particularly of excessive force, where Tyre Nichols was killed. And now the department's not going to be able to take action to help Memphis create fair and constitutional policing.
What was their argument when they said, "Oh, we're not going to, hold these cases or hold these findings up anymore. We're not going to back them"? What did they give you a rationale, or was it, "Oh, too much DEI. We gotta clean the streets"?
I don't think people on the attorney level got much of an explanation at all. The public explanation was that there had been this research done and they reassessed our findings. I find that really hard to believe that there was any meaningful research done, because the investigation process is just incredibly meticulous. And from what I've seen of this department, it is not. It is sloppy, it's roughshod, it's impulsive. They're doing things without any basis. And that's why when you see a lot of people folding to the department's demands, it's such a shame, because these things would fall apart in court. That's the kind of thing that you've seen with the law firms that have stood up.
Lawyers who may be willing to make arguments that experienced practitioners would recognize as legally untenable. We built this platform specifically to cover stories like this, stories that get lost in the noise of daily political coverage, but that fundamentally shape how the government actually works. Real stories, real context, no corporate spin. And if you want to stay informed about what's really happening inside the institutions that matter, join our community. The link is in the description. Now let's get into the details of what's actually happening at the Department of Justice and why it matters so much for the future of American governance. Let's start with the Civil Rights Division, because this is where the departures are most dramatic and most well documented, and because the nature of what this division does makes the mass exodus there particularly significant. The Civil Rights Division is responsible for enforcing federal civil rights laws across the country. It handles voting rights cases, employment discrimination claims, police misconduct investigations, housing discrimination matters. This is the part of the Justice Department whose entire purpose is to protect the legal rights of vulnerable people, those who might face discrimination or abuse from powerful institutions. When you lose 70% of the career attorneys in that division, you're not just losing lawyers, you're losing the institutional capacity to protect civil rights. The departures in the Civil Rights Division have been tracked by multiple independent sources. NPR reported the 70% figure, noting that the division has been fundamentally reshaped under the current administration's leadership. Justice Connection, an advocacy organization that has been monitoring the situation, put the number even higher, estimating that roughly 75% of career civil rights attorneys have been purged or pushed out. That represents an enormous loss of institutional knowledge about voting rights law, police misconduct cases, employment discrimination, and the complex web of civil rights statutes that protect American citizens and residents from unlawful treatment. Former division lawyers who spoke with NPR offered a consistent picture of what's happening inside the division. They said they believe the division is being redirected toward political priorities rather than neutral enforcement of the law. Instead of investigating police departments that show patterns of civil rights violations, the division is being pointed at targets that serve the administration's culture war agenda. Some of these former lawyers said they left specifically because they did not want to be ordered to ignore or downplay violations that their professional judgment told them were real and serious. This is not a theoretical concern. These are experienced civil rights attorneys who had spent years building cases against discriminatory practices, and they concluded they could no longer do their jobs with integrity under the current leadership. The combination of these mass departures and the stated reasons for leaving paints a specific and troubling picture. You have a critical law enforcement function being redirected for political purposes. You have an administration that apparently cannot afford to keep career professionals in place who understand what neutral enforcement looks like and are willing to push back against political interference. And you have the institutional memory of decades of civil rights enforcement walking out the door, leaving behind a workforce that may lack the expertise to recognize civil rights violations when they occur, or the willingness to pursue them when doing so would conflict with the administration's political objectives. Now let's examine the federal programs branch, because this division has perhaps the most direct implications for whether the administration's aggressive policy agenda can actually survive legal challenge. The federal programs branch is specifically responsible for defending executive branch policies in federal court. When the administration issues an executive order, when it implements a new policy, when it takes action that affects the rights or obligations of citizens, this is the unit that steps into federal courtrooms to defend those actions against legal challenge. The branch handles cases involving everything from birthright citizenship challenges to federal funding disputes to the administration's efforts to sanction law firms that represent its opponents. Reuters conducted an investigation into this branch and found that nearly 2/3 of its attorneys have either left or signaled their intention to leave. Out of approximately 110 attorneys, 69 are gone or planning to go. This includes at least 10 of the 23 supervisors who manage the branch's operations. These are the people who are supposed to defend actions like the administration's attempts to limit birthright citizenship, its efforts to strip federal funding from universities, the voter roll data, demands we've covered previously, and dozens of other aggressive executive actions currently being challenged in federal courts across the country. The people who are supposed to be mounting those defenses are leaving in droves. The reasons they're giving are particularly telling. 7 current and former attorneys cited punishing workloads and the need to defend policies they believed were not legally justifiable as key reasons for leaving. These are professional lawyers who spent years defending federal government policies across multiple administrations, including under Republican presidents. They looked at the specific policies they were being asked to defend under the current administration and concluded they could not be justified to a court on any honest reading of the applicable law. Rather than make those arguments anyway, rather than file briefs they believed were misleading or legally unsupportable, they left. The ethics dimension of these departures is the piece that makes this story truly alarming. Several federal programs lawyers told Reuters they feared being compelled to misrepresent facts or legal precedent in court. They said that doing so would violate professional ethics rules and potentially cost them their law licenses. This is not an abstraction. Lawyers have specific professional obligations to courts, to the legal system, and to their clients. If a lawyer makes false representations to a court about the facts, about what the law says, about what prior precedent requires, they can be sanctioned, disbarred, or even prosecuted for fraud on the court. The specific concern these attorneys expressed, that they feared being ordered to cross those lines, is a description of an environment in which the normal ethical constraints on government lawyering are being subordinated to political objectives. One former attorney offered a particularly poignant explanation of why so many of his colleagues were leaving. He said many of them joined the federal programs branch specifically to uphold parts of the constitutional system, to be part of the institutional force that ensures the government operates within legal limits. They could not reconcile that purpose with being asked to help dismantle agencies or retaliate against the administration's perceived enemies. This is a description of a fundamental conflict between professional purpose and political direction, a conflict that produces departures because the professionals are not willing to abandon their professional integrity even when their employer is pressuring them to do so. The broader picture of what's happening at the Department of Justice goes beyond just the Civil Rights Division and the Federal Programs Branch. Across the entire department, the exodus of experienced attorneys has reached proportions that veteran observers describe as unprecedented in modern Justice Department history. PBS reported that the combination of terminations and voluntary exits has erased centuries of combined experience from the DOJ, particularly among lawyers who handle national security and corruption cases. The New York York Times Magazine investigation describes specific DOJ components where the number of staff attorneys has fallen from 38 to as few as 2, from a functioning unit of experienced lawyers to a skeleton crew in the span of one administration. Former senior DOJ officials told reporters that nothing in prior administrations, including Bush, Obama, or the first Trump term, comes close to this level of experienced lawyers walking out. This is the key comparison that should anchor how people understand the significance of what's happening. This is not normal post-election turnover of political appointees. It's not the normal rotation of people who came in with one administration and leave when a new one takes over. This is career civil service lawyers, the people who are supposed to stay regardless of which party wins, leaving in unprecedented numbers because of what they're being asked to do. The high-profile individual departures add specific and vivid illustrations to the statistical picture. In the Southern District of New York, one of the most prominent U.S. attorney's offices in the country, the acting U.S. attorney and an assistant U.S. attorney both resigned in the same year. Their departures generated significant coverage because they came from one of the most visible prosecutorial offices in the federal system and were connected to reporting about pressure from the administration on how specific cases were being handled. When prosecutors at that level walk away, it sends a signal throughout the entire department about the environment they're operating in. An immigration litigation supervisor filed a whistleblower complaint alleging he was pushed to make unsubstantiated arguments in removal cases and was punished when he refused. His ouster rattled morale throughout the department because it sent a clear signal about the consequences of pushing back professionally on legally questionable directives. Whistleblower complaints are formal legal documents, and when they allege specific patterns of misconduct, they create a paper trail that can be used by future investigators, Congress, or special counsels to reconstruct what happened inside the department. And a Deputy Associate Attorney General, who was the lead attorney in the administration's court fight targeting 4 major law firms with sanctions, resigned in a recent year to join the private sector. This was the government's lead attorney in one of the most aggressive and controversial legal initiatives of the entire administration. He was scheduled to argue the appeal trying to revive the law firm sanctions after 4 federal judges had blocked them. His departure at that specific moment from that specific role signals that even the most loyal and highest profile defenders of the administration's most aggressive legal moves have their own professional calculation to make about how far they're willing to go. When you step back and look at all of these departures together, a consistent pattern emerges. The administration is systematically replacing experienced career lawyers with people whose primary qualification is their ideological alignment. The people who understood the institutional norms, who knew the ethical boundaries, who had built relationships with federal judges over years of practice are gone. In their place are lawyers who may be more willing to push the envelope, to make arguments that stretch legal precedent, to defend policies that experienced practitioners would recognize as legally questionable. And the courts are noticing the difference. The DOJ is not just a policy arm of the executive branch. It's a litigation institution. It files briefs, it argues cases, it negotiates settlements, it makes representations to courts about facts and law. The quality of those representations depends directly on the skill and experience of the people doing the work. When you replace 70% of your civil rights division with political appointees and ideologically aligned newcomers, when you lose 69 out of 110 litigators in the unit defending your most ambitious policy moves, you lose institutional knowledge, litigation skill, and the credibility that comes from experienced government lawyers who have built reputations for honest dealing with courts. What fills that gap is people who are there because of their loyalty and their ideological alignment, not because of their professional track record. And courts can tell the difference. We've seen it in cases where Trump-appointed judges have used phrases like fishing expedition to describe DOJ's legal theories. We've seen it in cases where the government lost 5 out of 5 cases on voter roll issues. That's what happens when a legal strategy is driven by political objectives rather than honest professional assessment of what the law actually supports. Let's be very clear about why this institutional picture matters so much and why the departures are producing the kind of legal vulnerabilities that this video's title points toward. First, we need to understand the relationship between experienced career lawyers and the DOJ's credibility with courts. When the DOJ files a brief in a federal court, when the government's lawyers appear before a judge and make arguments about what the law requires and why a policy is legal, the court gives significant weight to the government's representations. Not unconditional weight, but significant weight, because the government is expected to have the institutional knowledge, the professional integrity, and the depth of legal analysis behind its positions that produces arguments worth taking seriously. That deference is earned through the reputation of the career lawyers who have been arguing cases before those courts for years or decades. When those lawyers are gone, when the briefs are being written and the arguments are being made by people whose primary qualification is their ideological alignment with the administration rather than their legal track record, that deference erodes. And when courts start receiving briefs that seem to ignore obvious contrary precedents or that make arguments that experienced litigators would know are untenable, the erosion becomes a collapse. Courts start issuing opinions that use phrases like lacks a legally sufficient basis and stands the rule of law on its head. The whistleblower and ethical complaint dimension adds another layer of significance to what's happening. The whistleblower complaint about being pushed to make unsubstantiated arguments is not just a single employee's grievance. It's a formal legal document that documents a specific pattern of pressure on government lawyers to make legally unjustifiable arguments in federal court. The lawyers who told Reuters they feared being compelled to misrepresent facts or legal precedent were not speaking casually or anonymously about vague concerns. They were describing specific professional anxieties about specific legal obligations, the obligation to be candid with courts, the obligation to avoid making false representations to judges. The accumulation of these accounts across multiple divisions from lawyers who served under multiple administrations and who are not politically motivated critics is building exactly the kind of documentary record that can be used by future investigators to reconstruct how the department was used and abused. Every resignation letter that explains why someone left, every whistleblower complaint that documents what they were asked to do, every interview with a former DOJ official that describes the pressure to cross ethical lines, all of it is becoming part of a historical record that will not disappear when the current administration's term ends. The departure of the lead attorney in the law firm sanctions case at the specific moment he left tells us something important about the sustainability of the administration's most ambitious and legally adventurous initiatives. This was the government's lead attorney in a genuinely unprecedented and legally aggressive effort to use the court system to impose sanctions on major law firms that represent opponents or that have worked on cases against the administration. 4 federal judges had already blocked those sanctions. The lead attorney was supposed to argue the appeal, trying to revive them, and he resigned before that appeal was argued. The departure of the lead attorney from the most legally aggressive initiative the administration was pursuing at the moment when that initiative needed its best legal representation to survive appellate review is a specific and pointed data point about the professional assessment of that initiative's legal viability. Lawyers with good judgment and professional integrity do not typically walk away from cases at their pivotal moments unless something about the case or the direction they're being asked to take is incompatible with their professional obligations. The departure of this lead attorney, like the departure of his predecessor in that role who also left, suggests that the people closest to the law firm sanctions litigation were reaching professional conclusions about it that were not consistent with continuing to argue it in good faith before a federal appellate court. Now, to give the complete picture, the administration and its supporters have a consistent response to the departure narrative that deserves to be acknowledged. They argue that the career DOJ lawyers who have left were themselves politically compromised. They argue that the department had been staffed during previous administrations with lawyers whose political sympathies made them unwilling to enforce the law in ways that align with the administration's legitimate priorities. They argue that cleaning out the ideological opposition from career positions is not an ethics failure, but a correction of a prior political failure. They argue that the specific policies being defended are legally sound and that the departing lawyers are simply unwilling to defend legitimate policies they personally disagree with. And they argue that the ability to hire people who are willing to vigorously defend the administration's positions is a legitimate management prerogative that any administration exercises. These arguments reflect a genuine political philosophy about how the executive branch should work, and they are made by people who hold them sincerely. Some of the departing lawyers probably do have political disagreements with the administration's policy agenda that go beyond pure professional legal judgment about what the law requires. The pure story of principled professionals refusing to cross ethical lines is probably somewhat complicated by the political environment in which these departures are occurring. But here's what those arguments run into when you apply them to the specific documented consequences we've been covering. The voter roll cases are 0 for 5, with Trump-appointed judges repeatedly finding that the DOJ's demands lack a legally sufficient basis. That's not a story of career lawyers successfully obstructing a legally sound policy. That's a story of a policy whose legal foundation was not solid enough to survive judicial review, argued by whoever was available to argue it. The deportation cases produced a Supreme Court emergency order blocking a specific flight in a vote that included multiple appointees of the current administration because the government failed to follow required legal procedures. That's not career lawyers refusing to enforce the law. That's the government failing to follow legal procedures that the court found were required. The ethical concerns being raised about being asked to misrepresent facts to courts, about being pushed to make unsubstantiated arguments, are the specific professional concerns that produce bar discipline and sanctions when they materialize in actual court filings. And the fact that multiple experienced litigators across multiple divisions raised those concerns independently, not as a coordinated political action, but as individual professional judgments, is evidence that the pressure to cross those lines was real and was coming from somewhere inside the institution. The bottom line is clear. Approximately 2,900 DOJ lawyers quit or were fired in 10 months. 70% of the Civil Rights Division's career staff is gone. 2/3 of the federal programs branch, the unit defending the administration's policies in court, have left or are planning to leave. Multiple high-profile prosecutors resigned rather than follow directives they found ethically compromising. A whistleblower documented being pushed to make unsubstantiated arguments. The lead attorney in the administration's law firm Sanctions Initiative resigned before arguing the critical appeal. And the lawyers who are willing to talk about why they left are describing a consistent pattern: pressure to make legally unjustifiable arguments, fear of being compelled to misrepresent facts to courts, a fundamental conflict between their professional obligations and what the administration was asking them to do. That pattern and the institutional consequences it is producing in courtrooms across the country is the story behind the fear of conviction framing. Not a specific personal fear about a specific upcoming verdict, but a systemic erosion of the legal capacity and credibility that the administration needs to defend its most aggressive moves and to maintain the institutional protection that a functioning DOJ normally provides. The lawyers who understood the difference between defending a legally sound policy and making legally unjustifiable arguments to courts are gone. The ones who replace them are arguing cases before judges who have read the prior briefs, and the courts are noticing the difference. But if you think the DOJ lawyer departure story is the most significant sign of institutional erosion inside the current administration's government right now, wait until we get into what's happening at the intelligence agencies, where a similar pattern of experienced career professionals being pushed out or resigning over concerns about politicization is beginning to produce its own set of public consequences. Because the DOJ is not the only institution that is losing the people who know where the lines are. And the accumulation of those losses across multiple agencies is producing an institutional picture that has no precedent in modern American government. That story is coming next, and you're going to want to be here for it.